Father, we ask your blessings on this group and on our families. We ask your blessings on our nation. We are here for the purpose of trying to keep our country in good order and doing it according to natural law, your law that you put in the hearts of men. And we ask that you help us in our endeavors and that you give us wisdom and courage in our endeavors. We know we're acting in accordance with the law, and you, Almighty Father, have allowed us to do all this research and to know that we are acting lawfully, not in rebellion. We certainly are not in rebellion to you, Almighty God. We ask all this in the name of Jesus Christ our Lord. Amen. Amen. Okay. So yesterday we left off, and there's a few things that I wanted to bring up. Bill Price wants to bring up a point about preliminary hearings. What was that, Bill?
Well, since one of the most effective things that we've had so far is stopping prosecutions in a lot of cases,
yeah.
The steps that are utilized to do that in a preliminary hearing are crucial. And one of those steps is that in demanding the evidence that we'll need to defend ourselves, we persist, and if we're given any trouble, we go to a judge and get a discovery order. After we receive that, the thing about a discovery order is it's only as good as you use it. So if you have documents that you're requesting from a certain agency, you just have to know that you have to direct your questions to the agency that has those documents. That's one of the things that we've had people run into in the past, that they'll send a request to the wrong place. Right. And these people will play dumb deliberately. Right. And so and the prosecutor's not going to help you out. So it's not a very complicated thing to do, but you just have to be aware that if you're looking for records that the police department has or the city hall has, that you direct your discovery request.
And there's another point too that you ran into on one case where they wouldn't take the request for admissions or interrogatories because you hadn't served them on them, wasn't it right?
Right.
So you might want to have somebody 18 years old or 8 older, walk them in and serve them, and then sign a proof of service form.
Right. The gentleman that I was helping didn't serve it properly. If he had done so, we would have been able to ask for a dismissal based on the fact that this person was not going to answer the questions. We framed him in such a way that he wouldn't be able to answer, and if he would have done the service properly, we could have used that just to get rid of the case right away instead of actually going to trial.
There's one other point. There's an ad limine motion. You remember that, Bill?
Yeah.
Okay, the ad limine motion is to the court, and that bars the prosecution from bringing up matters that they refuse to respond to in discovery. So, for instance, if they say that you did something, and you go in and you ask for a sworn statement from the officer or whoever it is that he had personal knowledge that you did something wrong, then and if they refuse to give you that affidavit or testify to that, or make a statement or provide you the documentation that you're requiring, you can file an ad limine motion to the court, barring the court from bringing that issue up. That's why I keep stressing the idea, our laws are really good. Court rules are really good. Okay, so I'm going to leave that up there for a little while so that people will remember ad limine motion. That's, and if you had a little legal dictionary, you could read it in there. So I'm going to remind you that it's very important to have a little legal dictionary. I mean, it costs you like 12 bucks or something, and you've always got it. And I'll tell you what, I consider this as valuable as the Black's Law Dictionary, the big, thick one, because this gives you a lot of little information that you wouldn't have even known about. Definitions of different kinds of knowledge. And it kind of is almost like an instruction book. So I really highly recommend this. There's a couple things. We left off yesterday, we were talking about how to write up a complaint. There's 4 things you need in a complaint. I gave you copies of the Idaho court, how to file a complaint pro se. And I said that was very good. But I want you to look at something else now. You need 4 things to establish your claim. You need to establish that there was a law broken. In other words, if somebody did harm to you, they had to break a law. It would maybe be, I mean, something as simple as maybe an ordinance law. But remember that all law is passed by the state legislature and the Congress. Those are the only law-making bodies. So please remember that every time they throw an ordinance at you, remember they have to present you with the law passed by the state legislature or the law passed by Congress. It's not, they can't come up to you and say, we, the township board, are a lawmaking body and we write legislation. They can't do that. That's why in all the language of the state codes, it says that a township may adopt legislation that was passed by the state legislature. The same way with federal. You have, remember we talked so much about the requirement of statute and regulation, right? There's something very similar, it's almost exact same thing in the states. The state legislature passes a law. They do not implement the law because they are a legislative body, not an administrative body. So the townships and the counties are the ones that are authorized to carry out or affect the laws. So they have to refer, though, to the law that was passed by the state legislature. So it's the same thing, a statute and regulation on the federal level, a state law statute or public act, and a ordinance passed on the local level. So just keep that in mind. Now, the 4 things you need to do, the first one is some kind of law or injury, crime, whatever. But remember O.J. Simpson? He was prosecuted for a crime and he was let go. I mean, the jury let him go. But then they prosecute him on a civil suit for the same things. And they won that civil suit. Now, the point is that even there must be some criminal or civil law that was broken to establish your case. You're trying to establish your case, and you're the plaintiff here. Number 2, You have to establish that there was a duty by the defendant to do something or refrain from doing something. Supposing he acted in a careless and negligent way. That's violating his duty to be responsible and act in a responsible way. If you're driving a car, you have a duty to drive that car with reasonable care. And that's where, I think, where you would find a reasonable person. You'll always run into this in law cases. A reasonable person wouldn't have done this. So let's just put in parentheses here, reasonable person. Now, a person also can be a corporation. It could be a fictional entity. It could be trust. It could be a flesh and blood person. I think the way why they made that in law, so that whether you're suing a real life flesh and blood person or a corporation or a company or a government agency, you can refer to them as a person in your lawsuit. A lot of the patriot mythology says, well, I'm not a person. They'll say because persons are corporations. You'll find something in the law that says a corporation could be a person. So then they leap to the conclusion that only corporations are persons. That's not logical. That's why I asked you to always think in logical terms. Just because a corporation is a person doesn't mean other entities can be persons too. So don't fall into traps like that. Number 3. You know what the word proximate means? Who wants to tell me? What does the word proximate mean?
Close to.
Or next to?
Ballpark.
No, next to. Like Hal is proximate to the gentleman next to him. You're proximate to the gentleman next to you. So proximate means that proximate cause of damages. Okay, so you have to establish that the person who violated something up here, or failed to do something up here, he was the proximate cause to the damages that you got, the damages done to you. Now, I think a lot of this has been forgotten in law by some lawyers because they want to sue like a gun manufacturer for damages. If somebody goes out and shoots somebody, the gun manufacturer wasn't the proximate cause of damages to the injured person. And the gun manufacturer wasn't even close to being the proximate damage. You could say the guy that failed to stop the shooter was more of a proximate cause of damages than the gun manufacturer. Because the gun manufacturer didn't have any contact with the person who did the shootings.
And it would be the victim's fault.
Pardon?
Again, it would be the victim's fault.
No, no. It's your fault. Your fault. Everything's your fault. No. Number 4, and this is where at the bottom of your complaint you have to cite your actual damages. So you not only have to say the damages were caused by this person who was the proximate cause of the damages. Like for instance, I give the example of, say you're sitting at a stoplight and a car pulls up behind you and he stops. But somebody comes up behind him and rear ends that car and drives that car into your car. Now, who is the proximate cause of the damages to your car?
The one right behind you.
Nope.
Guy back again.
Guy back at him.
Gun dealer.
What?
The gun dealer.
Okay. All right. Because the guy was thinking about buying a gun when he hit it. All right.
Well, now, I've seen accidents though where the guy right behind him is the one who gets the blame, and then he has to turn around, his insurance company has to turn around and go out to the next.
No, you could not sustain that in court. No way.
The one who's really at fault, he's right, is the one that has the most money.
Well, I heard a lawyer say to the judge, he says, well, Your Honor, to be honest with you, I have to go where the money is.
Yeah.
He said that. So he was suing a corporation. Okay. But anyway, no, the proximate cause is the person who caused the damage. The guy sitting there that stopped behind you, he didn't cause anything. He did everything properly as a reasonable person would do. This guy behind him that rear-ended him drove his car into yours.
So my son got ripped off.
I guess so. Do you think it'll happen again?
Yeah.
Do you think it will happen again?
Probably somebody else maybe, but it won't happen again.
Well, I'm hoping that the people in this class, when they come away, that stuff's not going to happen to them again.
Now, could she go back and sue that person for fraud?
With the attorneys for malpractice, the judge, she could get a void judgment on it. She sure could get a void judgment. I wouldn't try to sue the attorney unless you're real sure. No, I'm serious. Because the attorneys will throw the kitchen sink and everything else at you. And then you'll just be a mess. But you can do a void judgment. That's simple.
On the actual damages, it says in here that for federal court, it has to be 75,000 minimum. Well, if you read farther, it says, read sooner, it says, or $75,000.
Okay, what is the first part of that sentence?
I'll tell you here in just a minute. Okay. The case must deal with a federal question of law, or
Okay. and
be
what?
$75,000 or more.
Okay.
So it was on the page before, if you, it kind of caught my eye, they're split up in the middle. Number one, it must be that or number two.
Okay, so it's a federal question. And I've seen so many people not read the or clauses properly. And, you know, when you've got an and in between two clauses, you're saying both of these must happen. If you got an or, you're saying either this has to happen or that has to happen, not both of them. So remember that it's part of our English language, which I think we've lost. But anyway, yeah.
On page 30, the IRS, or the actions of the IRS and its agents acting on false and fraudulent information provided the official literature propagated by the IRS was the proximate cause of damages to each plaintiff.
Yes.
So on
That's our lawsuit. That's
paragraph 30, Chuck Conces is listing the damages and names who the approximate cause of those damages are. So if you want to turn to page 30 or paragraph.
Now, is that the lawsuit that you passed out?
Yeah.
Well, okay. Yeah. But remember, you've got to establish these four things. Now, there's one more thing that you got to consider, and that's the immunity factor. And remember, immunity is based on only if the agent acted in good faith. Means he answered your questions, he tried to do everything a reasonable person would do as an official. Does the IRS act as a reasonable person? I haven't seen it yet, really. Well, maybe on very, very rare occasions. And the IRS is a person. It's a fictitious entity, but it's suable in court. That still hasn't been settled because the judge has barred disclosure. You know, he's actually, that's why he's vacated his office, because he barred disclosure on a matter that was crucial to the whole case. Was the IRS a official, separate entity from the Treasury Department and from the United States? We could rewrite that lawsuit. I would almost rather have each person, all 100 or some, file a separate lawsuit in their own district. Pay $250, flood these skunks, these judges, and then we'll vacate every one of those judges that won't allow discovery, that won't allow full disclosure, and protect the IRS. I would suggest maybe that would be the best course of action. I've thought about that many times. It would be very easy to change the lawsuit to Sally Mae and Joe Blow suing the IRS. It would be very easy to do. Now, we could also sue the individual IRS agents in their personal capacity. Because you have sued the IRS as an entity, and Mark Everson as the principal agent for the IRS, doesn't mean you can't sue an individual agent for stepping out of his official capacity. We could do thousands and thousands of lawsuits on personal, because these agents violate the law every day of the week. The good thing is that it seems like they're backing off. They're really starting to send out letters that are of a different character and nature than they used to send out. In fact, they've slowed down. But I see this because a lot of people will email me and say, well, I got a letter of this, letter of that. And a lot of it now is saying that they're backing off from, we're going to levy you, to it's our duty to inform you that we, you owe this money.
Nicer, kinder IRS.
That's a nicer, kinder judge. Yeah, right. I got a bridge to sell you.
The Internal Revenue now is sending out letters apologizing. I received one.
Okay, what did it say? Do you remember?
Well, they're sorry for any inconvenience.
Yeah.
That they will get back within a certain period of days. They don't know how to answer. I would suggest that if you're getting any other letters from like the state, you take that with the usually unidentified letter from the state, and you staple that on there with your cover letter stating that the IRS is apologizing, and that
Another thing you can do is take their, usually they send you 2 copies of the letter. Okay? Take one of those letters, keep one for your own records, staple the envelope onto it so you know when it was sent to you and you have proof of sending. Take the other one, mark fraud on it, and then attach the criminal complaint and the cover letter to the operations manager or the IRS. There's a cover letter I got for the criminal complaint. So just mark fraud on their paper, put the 48-page criminal complaint to Judge Bell, and then put the cover letter I've got in there for the criminal complaint. 3 things. So the thing is, they are taking notice. I mean, they're slow to wake up, smell the coffee. But the coffee is cooking. And these guys are cooking. They're probably having Monday morning meetings saying, what do we do now? I'm telling you, these agents go into an absolute panic. I've seen it time and time again. I've seen one of our guys in the employer got the agent on the phone. And the agent just hung up on it. I mean, and the employer said, gee, that's weird. Well, yeah, it's weird. Why do you think they did that? Anyway, I've also got a letter to employers, a new letter, if anybody needs that. I can send it out from the Lawman Public Interest Group. It's from that, but it's the National Lawman Public Interest Group. We could always also do one from the State Public Interest Group. We send that to the employer, I sign it, get my signature notarized, I send it by certified mail, send it to the employer, give him like 15, 20 days, I don't know. And then we'll go from there. We have to report a crime to some official. And the official we're choosing is Mike Cox, our illustrious Attorney General. You know, the guy with the gold braids up here and the cap with the bill on it and the brass running off. That's him. You see him walking down the street. So anyway, Mike Cox is going to be our pressure point, and we're going to, if Mike Cox will not uphold the law in the state of Michigan, he allows the IRS to operate in the state of Michigan. Considering all the fraud they're involved in, then he has vacated his office. He's refusing to uphold the laws. And we'll make a notification to Mike Cox. And then if he refuses to respond to it, we'll give him a certain number of days, then we publish it in the papers. Same way with our congressman. I mean, why should we mess around with these people?
What is the follow-up to that, though? I mean, as far as any must? I mean, you're notified.
He doesn't have any authority to act anymore in his office. He's vacated. If he does anything in his office, we're going to protest. You could file a civil suit for him impersonating a state agent after that point.
Can we get this publicized?
No, I'm saying we'll get to the point where we're publicizing the stuff, but you have to give the agent notification and time to respond. You don't just blow newspaper ads all over the place, because you will end up on the short end of that stick.
Yeah.
So use prudence and procedures.
10 days.
No, look, he's an agent. He gets maybe 1,000 mails every day. He's got to have time to go through them, or his secretary or somebody.
What's the time that we're...
Well, I would say, what's a reasonable time?
60 days.
30 days is a reasonable time. 60 days is plenty of time.
Well, you know
But I mean,
he's
you
not
have-
going nowhere.
Pardon?
You know he's not going nowhere.
That's right. That's right.
And you look better if you give him 60 days to respond and have notified him officially, and he doesn't respond within the 60 days, you having proof that that notification was actually delivered, then they look like they're not reasonable people for getting
That's right.
back. You know?
Another tactic you can use is give them a 60-day notice, and after 30 days, notify them again and say, you haven't responded yet, and you still have another 30 days to respond. But after that point, Mr. Cox, we will notify the public that you have vacated your office because you have performed an act of defiance against the Constitution and the laws of the United States, and an act of defiance against the laws of Michigan and the Constitution.
3 times you're out.
Well, well, actually, that would be the second notice. That would be like in the middle of the time period you gave, if you gave them 60 days. We could also have members of the lawmen also send in letters, repeated letters telling Mike Cox that, hey, we want an answer to this. What are you doing about the IRS agents? Are you going to allow them to operate in our state after all the fraud that we know they're involved in? Our deprivation of our constitutional rights. Are you going to turn a blind eye to criminal activity? Is that your method of operation? If it is, and you do not respond by the date we say, we will publicize all of your wrongdoing because you become an accessory after the fact.
And have been presented with evidence, like in my case where I presented it with evidence, irrefutable evidence. The IRS is using a letter that's a total fraud. I've shown that to Mr. Cox. It's from an agent by the name of Stephen P. Warner. And now he has evidence in his hand, and he has to do something with it. He has an obligation as the highest law official in the state of Michigan to do something. So the ball is in his court, and if he wants to deal with the re-election problem of having an official challenge on his office, this is the problem for Mr. Cox. He doesn't want to go into the future here with having that sort of official challenge on him.
Right, yes. Ken.
This concept can be used in other regulatory agencies that are
Yeah.
not upholding their
Yeah.
office.
That's right. That's right, but you have to lay the paper trail out. You can't just make accusations without being able to prove it. So lay the paper trail on it. You could do it in Michael's case. For instance, you could lay the paper trail on the judge, and tell him that he violated this statute or that statute, but you have to get him either to admit the wrongdoing or refuse to even respond.
Right now, there's pressure on the judge. Letters are going to him.
Okay.
Because one issue, there's many, but I did what you said on one. They do not allow him even to have a pastoral visit, and letters are going to the judge asking him to answer why.
Yes, okay, good.
So right now, that's in the making. A pastor is sending this letter. A
Right.
pastor has sent a registered letter.
Okay, but you should give the judges limited time to answer. Tell them, if you don't respond within 20 days or 30 days,
Okay.
then it will create a presumption in law that you have violated this or violated that or violated somebody's rights. There is a law in Michigan that says that they're supposed to have people that are able to live on their own outside of an institutional care, right? There is that law. Cite that to them. Say, do you dispute that law? Do you think in Michael's case that law doesn't obtain to Michael? Tell me why. Explain to me. Then if he refuses, then you tell him he's created a presumption that he's just violating the law. And he's violating Michael's constitutional rights of law, protections of the law. Because that statute is a protection of the law for people who have been injured, so that they won't be unnecessarily put into institutions. And this business about not having visitations, that's criminal. I don't know, there's got to be stuff in that, but you find, if you dig for it, you'll find stuff. So, oh, yeah, Ken.
I think this from your material or someone else's material. Most often these cases are handled by assistant U.S. attorneys, and if you file a complaint against particular assistant attorney, that's bad for promotion or continuation of the position.
Well, we could, but see, my problem was when I asked to meet with the prosecuting attorney, he wouldn't even answer my letter. Now, if I had time to go back after him, I could have pressed that issue. But frankly, I have to pick my battles. We've got 1,000 battles out there to be fought. We have to pick about 5. Yeah.
So my question was, is it true if you have a complaint against an assistant attorney or a judge, that would be on their record? And for future re-election...
you mean if you write up a formal complaint like
right.
this?
Yes. Against an assistant attorney for not doing their job?
Yeah, but if you're going to file a complaint, a lawsuit against him, or are you talking about a criminal complaint?
Whatever the case, that the assistant attorney is not doing his job right.
Okay, if he's not...
Or the judge not doing his job.
Okay, if they are refusing, and you've laid the paper trail out, if they're refusing to uphold the laws and the Constitution, then you could file a criminal complaint on them. And the criminal complaint doesn't cost you anything.
And then it will also stay on the public record that he has a complaint or she has a complaint against that person, and then it's bad for promotion, for his promotion to upper higher?
Well, I'm not worried about the promotions.
Well, because if it's affecting their future, they will be more careful.
Well, maybe so, and it might work. I don't know. I haven't tried it. You try it. I'm not, the only time we're using that is against the judges who, when they vacate their office, they're not entitled to a salary or to sit as a sitting judge or their retirement. That's a misappropriation of federal funds.
I know lawyers do not like a mark against someone's complaint because
Yes.
as us, we can find out if there's complaints against that lawyer before we would even hire him. I mean, I'm just talking about, they don't like to have that mark on them.
Yeah, you could do a criminal complaint against a lawyer, but I'm telling you, if you go against a lawyer, make sure you got all your ducks in a row and stay on point. Don't get off into all this other stuff. That's one of the hardest things people have to learn, is to stay on point. Don't get distracted because the lawyer starts talking about apples and oranges and bananas and grapefruit. You stay on your point. If the lawyer starts talking about extraneous stuff, you say that's irrelevant. That's smoke screens, and that's what they do. Or if the judge suppresses evidence or suppresses witnesses, bars witnesses, there's all kinds of things but always lay the paper trail on them first. That's what we've done with these judges.
Absolutely.
We've been in court many times here in Western District of Michigan, and we got the paper trail on these guys.
There's no denying for David W. McKee,
That's right.
for Judge Quist,
He's committed felonies.
Judge Enslin,
Yeah.
Judge Bell.
I'll tell you what, the guy that would have the most defense might be Judge Enslin if he said he didn't know this or he didn't know that. But he has a duty to know this stuff. He has a duty to know what his magistrate judge is doing when she's acting in his stead.
The law says his lack of knowledge would be unexcusable.
Yeah, right. That's right. If you look in your legal dictionary, it says there are certain kinds of knowledge that a lawyer or a judge is expected to have. That's inexcusable.
That was an excuse a state regulatory agent made about the judge's unjust judgment, that we just needed to educate the judge better on disability rights.
Okay, so in other words, the judge was not competent and may still not be competent.
Right. That was her remark. It is our duty to educate the judge after he's done an illegal act to harm somebody.
Well, you have to notify, but supposing you notified the judge and the judge still refused to correct himself, then he has knowledge and he has willfulness. See, I think that woman was saying that basically we have to notify the judge first before we charge him with a crime. But if the citizen notifies him and the judge refuses to answer, he's already been notified.
Well, they were just passing the buck. They were
I know,
just
but
excusing.
I'm telling you, Kathleen, this is their logical reasoning behind what she said.
Okay,
I know they're trying to pass the buck,
okay.
but that's beside the point. The point is, that's their logical reasoning that they use. And you have to be aware of what's admissible in court and what's not admissible in court. You may make a conclusion as to what the judge may have thought or about what he was thinking, but that's not admissible in court. You're not a mind reader. I'm not a mind reader. So you have to lay the paper trail on them. That's why we do this.
In the standpoint, you have to look at this whole picture. What we're trying to do is apply sufficient pressure on just a few individuals. And the whole purpose for that is, once one of these guys falls, it's just about over.
The game is going to
The
be...
game's up. So we all have our individual battles, and I'm involved in a lot of other things as well. But the purpose here is to get the pressure sufficiently applied to certain individuals to where they have to be accountable, and this is what we're doing right now.
Yeah. And this is all very important to the whole legal process. And this is what protects you. This is why we don't run and hide. And this is why we're not fearful. I can tell you right now that they're trying harassment tactics and scare tactics on a few of our members. Thursday, they tried a scare tactic on one of our members. Not for something we've told them to do, you know. Actually, I'm not going to mention what it's about, but I will say that they sent 8 agents into a restaurant to arrest him. 8. Like, what is this guy? Al Capone with a machine gun? I mean, that's just pure terror tactics. As like I say, the IRS is the largest terrorist organization in the world. That's all they have to rely on is terror and fear. That's all they do. Yes.
How can they do any arresting anyway? They're not a law enforcement agency.
That's right. That's right.
I mean, what would stop you from shooting them out when they come to your house?
No.
I know you don't like to hear that, but
I don't even want that suggested. You know what?
What's the alternative?
You know, that's a funny thing, but we're dealing with serious things here.
right.
And if anybody makes threats, I don't care if they're even veiled, the judge will use anything he can against you or anybody else. So I want you to, I'll give you an example. There's a fellow that's doing 40 years in prison, 40 years without possibility of parole. There was all kinds of irregularities in that case. I attended the trial. I was a character witness for him. I didn't have personal knowledge about various things, so I couldn't testify as to certain things, but the judge said, because he had made a statement on the phone to a fellow, and they were recording, he made the statement, they should have hung these judges. The judge says, I consider that a threat to me. He said that in court. Another thing they did in his case was the ATF agent got up and said he carried a weapon from one point in his house and stood a loaded weapon up in a corner next to the window. And he was going to shoot agents that came to his house. That's what the agent said. Well, he has no personal knowledge that he was planning on shooting anybody. He had no personal knowledge as to why he moved the weapon at all. He had no personal knowledge as to the motives of the guy. But the gentleman who got convicted never made one objection in his whole trial. He could have objected to that. He could have objected to the judge's statement. But he told me personally, he says he was relying on some high power, this was his term, high power legal defense. Guy named, well, I won't name him. But I'll tell you what, because he was relying on this guy, supposedly, that knew what he was doing, a patriot, he's doing 40 years. That's his whole life. He'll be dead by the time he gets out. And I'm telling you, I've seen this over and over again, and I'm telling you, be careful. We will not tolerate in the Lawman organization any threats against any judges or individuals. We will not tolerate it. If you want to do that, you go somewhere else. So just so we're all clear, okay? We got it on the record. Okay? So I hope everybody here agrees with that, okay? Anybody disagree, raise their hand and leave. If you don't leave, you agree with my statement. Okay. So, now, let's go into some of the rules. Are there any questions on lawsuits or criminal complaints that you have? Did you not understand any of it? Is there any problem understanding the lawsuits? Yeah.
Fraud is only civil? Or can it be civil?
No, fraud is a criminal act.
Criminal act? So I filed my claim in a civil court,
That's all right.
but I'm,
That's why I gave you the O.J. Simpson case. Because his was a criminal act, and they sued him civilly for damages for criminal act.
because that's, I sued in the civil court for fraud.
Right. Now, one of our judges, one of our famous judges here in West Michigan used that argument, and I answered it back. The criminal act, if it does damages to me, I have a right to sue him civilly, just like in the O.J. Simpson case.
I don't understand that. If he was found innocent of the criminal act,
Well, there's a different standard.
for a criminal act that he didn't commit.
There's a different standard for criminal juries and civil juries. One is a criminal complaint where he's subject to certain penalties, right? Criminal penalties. Okay, civil is where it's a controversy between you and him. You suffered damages, so you sue him civilly.
Don't you have to prove he committed the damage? Proximate person.
Yeah. But you only have to have 51% of the jury in a civil case agree with you. In a criminal, you have to have unanimous opinion of the jury. Now, the judges will instruct the juries in criminal cases. They'll say, I'm not sure if this is proper, but this is what I've heard them do. They'll say, the jury, their instructions to the jury, you must come back with a unanimous verdict, either innocent or guilty. Okay. And sometimes the jury will come back and say, we can't reach a consensus. And so he'll say, go back and try harder. So they'll come back and finally one side or the other will cave in and then they'll all go unanimously. But that's pressure, putting undue pressure on jury members. And I don't think that's permissible. I think that's a violation of the standards of justice.
I thought a hung jury like that pretty much left the guy innocent.
Well, let him off the hook.
I should put it that, yeah.
Yeah, not innocent, but off the hook.
But in the eyes of the public.
They could retry it.
They could retry with a new jury, with a hung jury. Now, there's another thing I want you to be aware of.
That would be in violation of the constitutional.
Not the jury's hung.
Oh, okay.
Not the jury's hung.
There's another thing, let's see. There's another thing in a criminal trial, what they allow the defendant to argue in his closing statement. I object to this, but it's what they're doing. They'll give the prosecution like a 30-minute closing argument, okay? Then they'll give 30 minutes to the defendant. And then they give the prosecution an additional 15 minutes. So it's kind of like if we can pick apart your closing arguments to the jury just before they go off to deliberate, this is what we want to do.
You can object to that.
I think I would if I were
definitely.
Yeah, I would object to that.
Object.
I'd say, look, I made my closing statements, they made their closing statements, let the case rest on that. They had their chance to say everything they needed to say in their first closing statement. Why should they get a second closing statement?
The prosecution's getting an unfair advantage.
That's right.
They're getting the attention of the jury.
Yeah. And then the instructions to the judge, as a pro se, you need to be involved in what the judge is going to instruct the jury before the jury goes off to deliberate. You have that right to be involved in that instructions. So for instance, if the judge is going to instruct the jury and say, well, we all know we have a well-known duty to pay our taxes. Your Honor, that's not going to be allowed in the instructions to the jury because you're not talking about the income tax and you're talking about hearsay. You can't instruct a jury with hearsay. You can't instruct a jury that there's been a violation of a law here when the law is so vague that nobody can even understand it. The average jury member, the average person out in the public can't understand the income tax. All you got to do is look at the thickness of the book, Your Honor. Tell me how many lawyers, Your Honor, understand that book. How many are willing to swear that they understand all the court rulings that affect the 16th Amendment and direct taxes? How many lawyers and judges are willing to swear that they understand the Constitution? Have read it, understand it. Are you willing to swear, Your Honor, that you've read the Constitution and you understand it? Especially all the taxing clauses and all the Supreme Court rulings that affect the taxing clauses. If you're willing to swear to that, I want you to sign a statement. And then I'm going to ask you some questions. I mean, you may not be able to do it exactly that way, but it's the kind of thinking you have to get into.
Mindset.
It's a mindset. Yeah, it's a mindset. And do it, think it through. Just like, remember yesterday I was kind of giving an example of arraignment hearing. What I would say at an arraignment hearing, no, I don't understand the law, Your Honor. The court is claiming that I violated a law. Is that correct, Your Honor? Yes, Mr. Conces. Well, I know that in order for a law to apply to me or any member of the general public, there has to be a statute and regulation, Your Honor. No one has supplied me with a statute and regulation. And then, if they come up with a regulation or a statute that says you are liable for the income tax, if they can, they won't, they can't. You supply gold versus gold. I think I passed that out. It's on the 7608 paper. Section 7608, Authority of Internal Revenue Enforcement Officers. Okay, gold versus gold. In the interpretation of statutes levying taxes, it is the established rule not to extend their provisions by implication beyond the clear import of the language used, or to enlarge their operations so as to embrace matters not specifically pointed out. In case of doubt, they are construed most strongly against the government and in favor of the citizen. That is gold versus gold, 245 U.S. 151. That was in 1917, 4 years after the 16th Amendment was passed. And I would think that statute was aimed at the income taxes and the propensity of the government and lawyers to try to apply income taxes to everybody. And they did that. And one of the courts called the government out on that. Said, wait a minute, you guys, you're trying to impose a direct tax here, and this has been ruled on. And the government admitted, no, due to the recent decisions of this court, we do not claim that the 16th Amendment authorized any new taxing powers to the Constitution, to the federal government. The government itself admitted it. That's in our 27-page report. So, if the more you know, the less afraid you're going to be. Now, remember I told you yesterday, if you ever go in a courtroom, always go in with certain things prepared, laid out in front of you, like your judge's code of conduct. I was going to print that out. I missed that one. So I printed out 7608. Now let's look at 7608. Paragraph A. Now this is stating what authority of Internal Revenue enforcement officers have. Enforcement of Subtitle E and other laws pertaining to liquor, tobacco, and firearms. So now read that sentence again. and other laws pertaining to liquor, tobacco, and firearms. In other words, Subtitle E pertains to liquor, tobacco, and firearms.
That only.
That only. That, if you read that sentence, that's what you would have to conclude. Then it goes on in the next paragraph, any investigator, agent, or other Internal Revenue officer. So they're saying investigator, CID people, Criminal Investigative Division, they're talking about them, right? Agent, or other Internal Revenue officer by whatever term designated. Operations managers, that include revenue agents, supervisors, all these people whom the Secretary charges with the duty of enforcing any of the criminal, seizure, or forfeiture provisions of Subtitle E. Here they said it again. Or any other law of the United States pertaining to the commodities subject to tax. The commodities subject to tax. Is my labor a commodity? Under such subtitle, for the enforcement of which the Secretary is responsible, may, or Subtitle E, they may carry firearms. Now, if you look down in paragraph B, the others, the paragraph B doesn't say they can carry firearms when they're collecting Subtitle A or Subtitle C or this other stuff, does it? It eliminates the carrying of firearms in paragraph B. So it's got two categories of agents, one in A and one in B. The ones in A can carry firearms, the ones in B can't. Under Subtitle E, all these agents can, in respect to performance of such duty, make arrests without warrant for any offense against the United States committed in his presence. So, in other words, if they see a Subtitle E violation in his presence, he may make an arrest without a warrant. But it has to be committed in his presence. Or for any felony cognizable under the laws of the United States. Didn't say the laws of the United States of America, did it? If he has reasonable grounds to believe that the person to be arrested has committed or is committing such felony, well, there's probable cause. He has to have probable cause again. And he has to have personal knowledge of it. And he has to swear an oath statement to a judge. In respect to the performance of such duty, make seizures of property subject to forfeiture to the United States. Well, that's all falls under Subtitle E, the commodities tax. All of it. Now you get down to paragraph B, and it says, oh, by the way, for all those other subtitles, Subtitle A, Subtitle B, Subtitle C, D, all those, it needs a criminal investigator of the Intelligence Division. Well, the Intelligence Division is a division of the Internal Revenue Service that deals with either foreigners working here or citizens of our country working outside the country. And I want you to remember something too. Say like if you're a citizen of the 50 states and you're working out in France and you're earning money here. You are, I believe, the Constitution would not protect you from a direct tax without a portion, because you're earning the money outside of the country. So, they will tax you on it, but they will also give you a huge reduction right off the beginning. In other words, they'll say your first $60,000 or $80,000 of your earnings that year are exempt from income tax. So, they don't give us that when we work here in this country, right? But they give it to them for a reason. Because lawfully, it's going to be a terrible thing to prohibit our citizens from working and earning money in other countries. So they had to pass statutes or regulations that gave this huge exemption to people, our people that work overseas.
I worked in Canada one time.
Okay.
They never asked for a social security number. And it was the first check I ever got. There was nothing, absolutely nothing.
Okay.
That was a good deal.
It's very possible. Very possible.
But when I cashed the check, I cashed it in this country, and I got more money for it than it was. Because of the rate of exchange, the bank just cashed it at face value.
Why didn't you stay there?
I lived in England, and I had to pay taxes in England.
Yes, you have to pay the
I think
taxes.
one of the reasons they do that,
That's
under 80,000, is
You're
to try
right.
to even it out.
Trying to even it out, yeah, because you have to pay taxes to France or England, and then you have to pay this other tax. But you get a big exemption there, huge exemption. Yeah.
Where do the treasury agents fall in this scheme of things?
This is the authority of Internal Revenue. They claim to be part of the Treasury.
Okay. But they have treasury agents that enforce some of their rules and regulations.
Well, you have to look at what the authority of Treasury agents are. I don't see them having the enforcement power of law on certain things. They're delegated certain things, functions. Internal Revenue agents are the ones that are delegated to collect income taxes, alcohol taxes, or Subtitle E taxes. So,
On the front of your complaint here, you have the Internal Revenue Service, a private corporation.
yeah.
So that's how they're being identified here in the suit.
Yeah, in the suit, we identified them that way, and then the judge wouldn't even allow discovery on that point. Yeah.
Even though that we had evidence in
Yeah.
diversified metals
Yeah.
and the research done there that they were not an agency of the United States.
Yeah, and Chrysler versus Brown.
And Chrysler versus Brown as well. So we had the evidence, they just were afraid.
So I can't really answer your question. Have you ever been approached by a Treasury agent? Oh, you have?
Yeah.
On the income tax?
Summons to appear as a witness against a person who has international.
Oh, okay. Did you get his card?
Yes.
What does it say on his title?
It says Department of Treasury.
Yeah, that's the name of the agency. What's his title?
I'll look it up right now.
Okay, because it might be important, because he may be misrepresenting himself as a Treasury agent. I know that some IRS agents think that they are part of the Treasury Department. And they would like the public to believe that. They put on their letters going out, Department of Treasury, Internal Revenue Service. But if you go to the Internal Revenue buildings, the actual buildings, they're not on federally ceded land. They're in office buildings, they're in shopping complexes. So if they were an agency, a part of the Treasury Department, they would have to be on federally ceded land. And then they would have on the stone monuments or the big signs out front, and they would have Department of Treasury, Internal Revenue Service. They never put Treasury, Department of Treasury up there.
And also, in the phone books, they're not listed under governments either.
Okay.
They're listed separately.
See, no,
They are in our phone book.
They've been changed, they just
they just started changing it?
started recently.
Okay, that's to fool the public.
Right.
Yeah. The other thing is that if you look at least your old letters from the IRS in the envelopes, they pay postage to send those out. Now, all government agencies have the franking privilege.
Aren't there laws against deceptive marketing?
Oh, absolutely, there's laws against
Mail fraud, mail fraud.
That's why we're saying, these people commit so many acts of fraud, it's hard to even count them up.
They tell you if you even tamper with the mailbox, you're going away for a long time.
That's right.
Look what they're doing.
They tamper with the whole citizens. citizen. But you know,
This is on the Internal Revenue Manual.
yes, it is. Yeah, but it's 7608 is that's a section number, and if you look in Title 26 of the U.S. Code, you'll find 7608. That's why I'm telling you this is extremely important, because this is the only section that spells out the authority of the agents by title. There is not another that I've ever seen in the Internal Revenue Manual, or the code, Internal Revenue Code, that has a section spelling out the authority of Internal Revenue agents of whatever. So that's it. If it's not in there, then gold versus gold applies. Cannot extend it by interpretation of statutes to any other matters. So I kind of pasted some of this together because I want you to be aware of what the courts have ruled. I mean, these are not just isolated incidences. These are part of our precedence law that has been established. Look at this one here. Well, here's the one I mentioned to you yesterday. In the context of criminal prosecution, we must apply the rule of strict construction when interpreting this regulation and statute. That's United States versus Bursky, 1960. And they also quote United States versus Helsa and United States versus Wiltberger. So in other words, the High Court is saying strict interpretation of the statute means you can't be loose with the terminology. It has to definitely point out who is mentioned in the statute, what applies to that type of person, what penalties are there, who is liable. Look what they've done in the Internal Revenue Code. They've actually taken statutes, and if you go back from the back of the, say, the Internal Revenue Code book, if you go from the back, you'll find like the 7201 through 7209. These are criminal penalty statutes. That's all they are. They are penalty statutes. And if you look at 7201 through 7209, I think it's those nets, you will find that a lot of them don't have even implementing regulations in the table of parallel authorities. Let me just check it. I want to make sure I'm on the right numbers here. Yeah. Okay, like for instance, 7208 is offenses relating to stamps. Okay, 7210 is failure to obey summons. Looks like they removed 7209. No, here it is. Unauthorized use or sale of stamps. Okay, they have stamps on liquors, they have stamps on tobacco, probably firearm stamps, I don't know. But those are excise taxes, and those refer to stamps. 7207, fraudulent returns, statements. It doesn't say what kind of return here. Okay, so in 7207, it's a penalty statute saying what penalties apply. Shall be fined not more than $10,000, etc., etc. That's penalty. That's all it says. And what they're doing is prosecuting the dumb public out here. Because it says any person who, it doesn't spell out liquor dealers, it doesn't spell out tobacco dealers, it doesn't talk about U.S. citizens. It says any person who And then you have to read the, it does not describe the person who gets this penalty. And they're trying to claim that these penalty statutes are sufficient to prosecute a person on. That's baloney. So, we know, so you would have to ask the court or the DOJ attorney, because you're not even going to court, you're going to ask these questions before you ever get to court. You're going to say, am I one of those persons who? And then you say, show me the statute that makes me liable. Okay, now, I can show you, and Chef points out the statutes that make people liable for gasoline taxes, alcohol taxes, tobacco taxes, and it says liable. It uses the word liable. Liable has a particular meaning. In fact, I don't even know of another word that even expresses the notion of liable very well. In section 1, when you get, say, to the beginning of the Internal Revenue Code, it says imposed. Okay, tax imposed. Okay, there's a tax imposed, but who's liable for the tax imposed? You have to have a liability statute in the middle. If they have a liability statute in the middle for alcohol, tobacco, and firearms, why don't they have one for income taxes? And if you really want to pin them down, go to the index, to the code. There's a section here that says liability. Liability for taxes. And you could go down through these and it lists you the code sections where the liability for this tax is in 5004 for distilled spirits taxes. In 7403 or 6324, estate and gift taxes. Then they have exceptions. But, okay, wagering taxes, 4401. And this is under the heading of liability. That's the middle part. So they've got liability statutes that describe who is liable for those particular taxes. But they don't have one for income tax. If you go in here, you will not see income taxes listed. You go from H to M. I is in between there. Highway motor vehicle use tax, 4481, and then manufacturer's excise taxes in 4219 and 4221. There is no income tax listed in there. So there's no liability for the income tax, and that's why they will never answer the question. Yes, sir.
I just sent off a FOIA to Washington, D.C. asking where I could find the liability statute for income tax.
Yeah.
They forwarded my letter to Detroit. They said they couldn't handle it. That was the answer I got.
Yeah. Well, we did it was a summons for the record of in a court case, in a federal court case, we did a summons to the Treasury Department for the delegation order to the IRS agent. And then 5 minutes before trial, there was a phone call supposedly to the prosecuting attorney, and he came and informed the gentleman that they had no documents responsive to that 5 minutes before trial. That was in Judge Bill's court. Ding dong. Oh, we got you. We got you. This is, the fraud is so palpable, but that's what the problem is with the country right now. It's not because our laws are bad. Our laws are good, the Constitution is good, is people like Mr. Bell and the other judges who are running cover for the IRS agents. They're accessories after the fact. And now we got the paper laid on them, and we can say that, and they're not responding. I notified all the judges that they vacated their office. I notified the Congress. I notified Senator Levin. Nobody's responded. So what does that say about them? Okay, so here's another good court ruling. This is 2002 ruling. That's why I like it so much, because it's so recent. Vague laws offend several important values. First, because we assume that man is free to steer between lawful and unlawful conduct. We insist that laws give the person of ordinary, that's in second page of the 7608, yeah, the second court case. We insist that laws give the person of ordinary intelligence a reasonable opportunity to know what is prohibited so that he may act accordingly. Thus, vague laws may trap the unwary because they do not provide adequate warning of the conduct that they seek to prohibit. Secondly, if arbitrary and discriminatory enforcement is to be prevented, laws must provide explicit standards for those who apply them. A vague law impermissibly delegates basic policy to policemen, judges, and juries for resolution on an ad hoc and subjective basis. Vagaries are not law. A statute may be held unconstitutionally vague if a person of common intelligence is unable to determine what conduct is prohibited, or if the statute fails to provide sufficient standards to prevent arbitrary and discriminatory enforcement. The record reflects that RC 2923, 1 through 4 fail both prongs of the test. They do not save the ban on carrying concealed weapons. They simply add a layer of confusion. And because of this, they rely on affirmative defenses for interpretation and contribute to the total prohibition against bearing arms. They are also unconstitutional. Court saying that it's constitutional to carry even concealed weapons. Trial courts have applied the law inconsistently, and appellate courts have done no better. Duh, no kidding. We mention these decisions of our colleagues not to criticize, but only to demonstrate that vague statutes are open to subjective interpretation. And that's what we're talking about here. They split up one statute into 3 sections, and they mix them up with alcohol taxes, firearms taxes, gasoline taxes, and we're supposed to understand all this. They won't even tell us where the statute for liability is. The result, which is confusing or opaque to the average citizen and to the police officers, lawyers, judges, and jurors, is an unconstitutional delegation of public policy matters. When the police, the citizens, and the courts all must guess at the meaning of a criminal statute, subjective and arbitrary enforcement results. So if you took that 2002 ruling, now this is from the Supreme Court of the United States, if you took that into court with you, you'd use that for a defense. And then you give them the brief on taxation of all those court cases. And say, well, while it may be confusing to this court and to the average police officer out there, Your Honor, it's not confusing to me because I've got all these cases cited here. So, another big thing I want you always to keep in mind is this Federal Maritime Commission versus South Carolina State Courts. That was 2002. And that is the one I mentioned to you yesterday where the judge must give all the findings and conclusions on all issues of law, facts, and discretionary matters to every party in a case. That's all underlined on the 4th page there. And I think I read that to you, but I wanted you to have that so you will have it there. And then also, 28 U.S.C. Code 455, any justice or judge or magistrate of the United States shall disqualify himself. In other words, he shouldn't even have to be asked to disqualify himself. He shall, in any proceeding in which his impartiality might reasonably be questioned. Well, at our hearing in Grand Rapids, I had 4 witnesses sitting back there, and every one of them told me afterwards this judge was biased, totally denying us our rights and everything. So, reasonable, I would say I would rely on the reasonableness of the 4 witnesses of my own. He shall disqualify himself in the circumstances, in the following circumstances, where he has a personal bias or a prejudice concerning a party. So he has a prejudice against us who are mere citizens. We are not part of the elitists. We're not part of the Illuminati. We're not part of officialdom. Yes?
If you go to court in front of one of these judges that have vacated their office,
Yeah.
is there anything you can do about that?
Yeah, I would bring that up. I would bring it up to the judge. And I would make an appeal on it. I would. I wouldn't let him skate by. I'd make an appeal saying until this court can establish the judge can establish that he has taken both oaths of office, have them on file, and give me a sworn statement that he does not know of any instance where he has violated his oath. I'd say until that point, I challenge the personal jurisdiction of this court to proceed.
And if he refuses to honor that?
Then you have to give him the federal maritime law case. Say, give me your findings and conclusions on these issues. And here are the questions that I'm asking. So you cite that federal maritime case to him and Judge Thomas's ruling, and then you say, I want the findings and conclusions on these issues of law. I want the findings and conclusions on these issues of fact. You list them, 1, 2, 3, 4, 5. Then you, if there are any discretionary matters, I want the findings and conclusions on those. Like for instance, you could say, I want the findings and conclusions on definitions in 3401. Who is an employee? Does that definition of employee fit me? 3401 defines an employee as being a government official or an employee of the government, does not say anything about a private citizen. That's how communism has been crept into our country. They misconstrue the laws and they do it knowingly and willfully. You have to confront them and you have to lay the paper trail up. See, in a case where you're actually in front of a judge, where you're challenging his personal authority to proceed and act as a sitting judge, you have to provide, you provide instances where he has violated his oaths of office. And he takes 2 of them, remember. Say, in this case, and you can cite our cases. In this case, you did such and such, and Bill Price and Chuck Conces are willing to come in and testify to that. That is sufficient reason for the average person to think that you are biased and prejudiced, and you have committed an act of defiance against your oath of office and the laws and the Constitution.